Today, we are bypassing the headlines. Instead, we're stepping straight into an imaginary account of the mechanics of the Supreme Court of India and what to expect in the MC Singla hearing.
We're dissecting today a facsimile procedural account to illustrate the architecture of justice, from argument to a reserved Supreme Court judgment, or how a courtroom battle becomes binding national law.
For this deep dive, we are drawing on two precise sources, starting with a meticulous step-by-step map of how a Supreme Court hearing actually works.
The second is a high stakes case file from a brisk March 11 morning, a masterclass in how major systemic decisions take shape.
The machinery of the court is a genuinely fascinating space to analyze because we usually only consume the end product,
The final judgment.
Yes, the final judgment that alters a national policy or defines a statute.
But the actual deliberative process is largely hidden from public view.
You're weighing individual liberties against the stability of massive institutional framework.
So, setting the stage requires understanding the physical and procedural environment of a final hearing, specifically before a division bench of two justices.
Our sources provide this brilliant description of the atmosphere. The exact phrasing used is that the courtroom operates as a theater of precision, persuasion, and judicial restraint.
Theater of precision. I love that description.
The court assembles exactly at 10:30 a.m. The justices take their seats, the court master begins calling the items, and the space is just immediately activated.
It's electric.
It's a room of senior advocates, juniors, and counsels, all distilling years of sprawling litigation into razor-sharp arguments.
Because punctuality in this context is not just about scheduling, it is a mechanism of control.
Makes sense?
With the court's crushing docket, strict timing forces advocates to hit only their most powerful arguments, not a second wasted.
It's 10:30 a.m., Thursday, 12th March, in courtroom number 2, so just 2 minutes after the court has assembled.
Very fast. Honorable Mr. Justice Vikram Nath and Honorable Mr. Justice Sandeep Mehta are already taking the bench and moving through the daily cause list to call the case we're tracking.
The court master calls item 1 row 2, Civil Appeal 79993, 2023 from SLP 5661, 2016, a case on MC, Singla and others versus PNB, Union of India, et al.
Now, the timeline embedded in those filing numbers is critical context for you listening.
Totally
Right, 2016 to 26. This case began its journey 10 years ago as a special leave petition, which is the discretionary gateway to the apex court.
Over the course of 10 years, it navigated the arduous process of being converted into a civil appeal.
It endured multiple adjournments, various interlocutory applications.
These petitioners have waited for a ruling that shapes their financial security as justice moves at a pace set by procedure.
It's heartbreaking to think about.
Which often runs counter to the immediate needs of the petitioners.
Exactly. And that brings us to the core grievance presented by the appellant's counsel.
Let's break that down. The appellants are retired officers and employees of nationalized banks.
Right. And they are challenging the denial of the periodical updation of their pensions. Basically, their argument is rooted in the demand for parity with RBI and serving staff's bipartite settlement.
Makes sense.
Right. The senior advocate for the appellants frames this not as a discretionary bonus or a gratuitous favor from the banks, but as a vested statutory right.
And the legal foundation for that claim of a vested right rests heavily on two pillars. First, they cite Regulation 35.1 of BEPA 1995.
Okay.
Second, they rely on a 1983 bedrock precedent in Indian pension law, that is the DS Nakara Updated Union of India case law. 1983.
That's a big one.
Huge. The Nakar judgment fundamentally shifted the legal understanding of pensions. It established that a pension is not a bounty payable at the whim of the employer.
It's not a gift, but deferred pay. Citing Nakara, appellants argue that denying pension updation with wage hikes violates equality and fair treatment.
Now, this is where it gets really interesting because the bench does not passively absorb this sweeping constitutional argument.
Not at all.
The lead judge actively interjects to test the mechanical reality of the appellant's demand.
They want the math.
The presiding justice may pose a technical query. What updation mechanism do you seek? Full DA neutralization or a merger aligned with bipartite revisions?
It's a pivotal moment. The court pushes counsel to drop abstractions and spell out the ruling's exact math.
Because the distinction between those two mechanisms is vital, right?
100%. DA neutralization protects against inflation, while BPS merger formula means recalculating the base pension by folding parts of the DA into basic pay whenever a new bipartite settlement reshapes salary structures. The judge's query shows the court has studied the charts. They're probing the limits of the relief sought, demanding the exact formula they're asked to mandate.
So the appellant clarifies their demand for a proportional recalculation based on the wage settlements.
Right? And then the dynamic shifts entirely as the respondent's counsel or the defense takes the floor,
The respondent's senior advocate shifts the lens from individual rights to broad systemic macroeconomic risk.
which is a completely different angle.
The stakes are huge. 11 nationalized banks warn that continuous pension updation would unleash major fiscal strain from unprovisioned actuarial liabilities.
That old chestnut, the poverty cry.
Right? And the respondent is arguing that the continuous dynamic updation the appellants are demanding was never factored into historical capital reserves.
True, but hasn't the court already heard that argument before and the actuarial account presented by Mysore Pensioners Commune undermined the bank's poverty plea?
So, to legally anchor this economic defense, the respondent's senior advocate deploys a precedent set in state of Punjab vs. Rafiq Masih from 2015.
It's a very long shot, so good luck to the defense with that precedent.
The case warned don't issue directives with open-ended fiscal fallout. The respondent urges judicial restraint.
Judicial modesty.
The argument is simple. Such sweeping restructuring is economic policy, squarely within the executive and the banking regulators' domain.
Not the judiciary.
Exactly, not the judiciary. And remember, we are neutrally presenting both sides here.
What's fascinating here is the sheer scale of the institutional tension likely to materialize in courtroom number 2.
It's palpable.
The bench is tasked with adjudicating between two completely valid yet diametrically opposed realities.
For appellants, the human stakes are clear. Pensions are a vested right, vital to dignity in old age.
And for respondents, the math is stark. Retroactive, unfunded liabilities could destabilize the very banks meant to pay those pensions.
It's a catch-22. A ruling strictly favoring the individual might risk the system.
And a ruling strictly protecting the system compromises the individual's legal rights.
Right. So, this tension accelerates toward the climax of the morning hearing when the government attempts to intercede.
This is a key moment.
The second judge would likely turn to the union asking whether the government has filed an affidavit detailing the fiscal burden of the sought pension updation.
And they have.
Yes, the ASG confirms a detailed liability affidavit is on record, then makes a pivotal strategic shift.
What do?
The union requests an adjournment.
He asks the court for additional time to explore a phased implementation formula.
The executive branch is attempting to pull the matter back into the realm of policy formulation.
Trying to buy time.
By seeking time for a phased rollout, the government signals a bid to soften the bank's immediate shock while offering pensioners gradual relief.
It's a classic administrative maneuver. Delay a binding judicial mandate while a softer policy compromise is negotiated.
The bench completely shuts down that maneuver.
Just shut it down.
The bench delivers a crisp rebuke. This case has lingered since 2016. The retirees are aging, and justice delayed is justice denied. Final arguments will be heard today.
That is intense. The invocation of justice delayed is justice denied is not used lightly here.
No, it is a direct assertion of judicial authority over bureaucratic timelines.
The court is explicitly recognizing the mortality of the litigants.
They don't have infinite time.
Right. When dealing with pension disputes involving an aging population, the timeline of the adjudication becomes as critical as the legal outcome itself.
So, following that denial, the hearing enters its final, highly concentrated phase. The next 90 minutes are consumed by fierce exchanges as counsel spar over the exact reach of the 1983 DS Nakara precedent.
Applying it to the specific regulations governing bank employees.
Exactly. And the bench tightly controls this phase, restricting counsel to addressing only what is strictly necessary to resolve the doctrinal tension.
No more broad arguments.
No, only the hard law. The public phase ends as the presiding judge closes the file, confers briefly, and issues the final word.
Heard. Judgment reserved.
That phrase marks a fundamental transition in the life cycle of the case.
The oral phase ends?
It ends, but judgment waits. The room empties, counsel fade, and elderly petitioners show characteristic restraint.
They're used to waiting.
The verdict remains awaited. It is crucial for you listening to understand that reserved judgment is not a pause or suspension of activity.
So, what follows those words? The focus shifts inward into the court's deliberative domain.
Yes,
The public theatre of precision dissolves, and this highly intensive, largely unseen phase of judicial labor begins behind the chamber doors.
it is arguably the most intellectually rigorous task the court undertakes.
I can imagine. The first step involves a meticulous independent review of the entire 10-year record by the judges.
Everything,
They sift the case's long history, marking pages, spotting contradictions, and isolating the doctrinal tensions across arguments and submissions.
but they don't do this alone, right?
Oh no, this critical role is performed by the court's research teams, specifically the law clerks embedded within the judges' chambers.
The unsung heroes.
Truly. The clerks shoulder the scholarship, mapping jurisprudence and tracing the evolution of every cited precedent,
So they have to dissect the Nakara case, etc.
and decades of rulings, all to show how this pension fight fits within the wider constitutional and statutory framework.
Right?
The clerks prepare highly detailed research notes that serve as the intellectual foundation for the drafting process.
And armed with this exhaustive research, the two judges on the division bench enter the actual deliberation phase.
Where they test each other's reasoning.
Exactly. They refine the principles, and judges often begin far apart in interpretation before slowly converging on a final view.
That friction of ideas is a required element of the process.
Makes sense?
If the core clash endures, balancing pensioners' rights against banking risks, the judges may even issue entirely separate opinions.
It happens. And the drafting that follows is exacting because a judgment's language shapes how courts, agencies, and litigants interpret the law for decades.
Every paragraph is vetted for absolute doctrinal accuracy.
The draft is circulated for concurrence between the judges, subjected to intense internal scrutiny, and continually refined until it is prepared for public pronouncement.
It's a massive undertaking.
So, what does it mean? This hidden phase of a reserved judgment is the court thinking aloud slowly and with constitutional care.
Thinking aloud slowly.
Right. We've traced the full architecture of this process, beginning in the courtroom's precise theatre and its charged, punctual energy.
Yeah,
We weighed the clash, aging pensioners' deferred wage rights against the actuarial evidence and the bank's claims.
okay,
We saw the bench assert its authority, denying delay for aging litigants. Then we followed the case into the secluded deliberative domain where argument and precedent are forged into binding law.
if we connect this to the bigger picture, this entire procedural journey really illuminates the immense burden placed on the judiciary.
Huge burden.
Behind every major institutional policy and behind the enforcement of every legal right you have, there is this exhaustive churning process.
Sure.
Justice's architecture demands a constant walk between empathy for aging litigants and the system's hard, necessary restraint.
Because a single ruling can trigger massive economic consequences.
Exactly. The system is designed to be slow, deliberate, and fiercely analytical precisely because the stakes are so high.
And that deliberate pace defines the system, leading to one last question for you to ponder as we wrap up.
Okay,
We've seen how a reserved judgment rests on slow, meticulous passing of precedent by judges and their clerks.
right.
As a new tech era dawns, how might rapid AI tools in these secluded chambers alter the pace and even the nature of this deliberative domain?
That is a fascinating thought.
If a machine can trace a century of comparative jurisprudence in seconds, what happens to the human element of thinking aloud slowly?
It's something the legal world is going to have to grapple with.
Absolutely.
Thank you for joining us on this deep dive.